In Heckler versus Chaney, the United States Supreme Court held that an administrative agency's decision not to enforce its rules is generally presumed immune from judicial review. In American Horse Protection Association Incorporated versus Lyng, the District of Columbia Circuit considered whether the same was true for an agency's decision not to engage in rulemaking. The Federal Horse Protection Act sought to end the soring of horses, a practice that involved attaching devices to a horse's front legs to induce pain, prompting a high-stepping gait. The act granted the Secretary of Agriculture broad rulemaking authority to adopt regulations prohibiting soring devices. Under that authority, the Department of Agriculture implemented various prohibitions. During the rulemaking process, the agency noted that additional prohibitions might be necessary in the future if supported by scientific evidence. A few years later, the American Horse Protection Association believed that certain developments, including the release of a university study on soring devices, demonstrated the need for more stringent regulations. It asked that the Secretary, then Richard Lyng, institute a new rulemaking proceeding to revise the regulations. The agency refused, stating that after review of the presented materials, it believed the Horse Protection Act was best served by persisting with the existing regulations. The association then filed suit against Lyng in federal district court, challenging the agency's decision not to institute rulemaking proceedings. Lyng moved for summary judgment. The district court granted Lyng's motion, finding that although the refusal to engage in rulemaking was subject to judicial review, the agency was entitled to deference because it had provided a rational basis for its decision. The association appealed to the District of Columbia Circuit.